Welcome to Justice Serve TV. We will go inside the Kelsey Fitzsimmons hearing from yesterday. Why? Because we were there. And hey, the SJC, watch out. You're on the clock.
Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Hey, Linda Kenney Baden. How are you?
Brian, good. Let's get right into that rip and read since we didn't have one last night.
All right then.
Okay, I'd like to play some cards. Oh, which deck would you like to play with, Michel Bryant? The red deck or
I like the blue. Yeah, I like blue.
Good. The blue. I had the blue out already. See, I could read your mind. You know.
Yeah.
Here's
It's a
my
short
cut
story.
card. Let's see. It's let's do a little shuffling. Okay. You can't see your hand, but I can. Ironically enough, interestingly enough, I could tell you what deck you wanted to play with and what cut card it's going to be. King of Diamonds. Is that good for you?
Okay.
Okay, it's not going to win because the Three of Diamonds is going to be the winning card. Now, why do I know all this? Because the NBA coach, in case you haven't been following, and somebody said that I would have a lot to say this, an NBA coach, a player suspended after federal arrest on unlawful gambling charges. That's my friend Earl Burton, who wrote a story on Poker News Daily. I know that we have a screenshot of it if you have it available. And if you don't have it available, then we won't screenshot it. Okay, we won't show it, but Earl Burton's a friend of mine. Does a great poker player, a great former coach. Well, let's see. A lot of you know Portland Trailblazers head coach Chauncey Billups and player Terry Rozier, who's still playing in the NBO, accused of being involved in a huge gambling operation stemming way back. The game, apparently, from my reading of all the poker newses and all the little subtitles and all the little chats going on. The big game in Las Vegas in 2019 may have been the center of this, where people first got wind that apparently it didn't matter what you were playing with. This is a face card. He's a face card. He was considered a face card. And what was he getting? What we call the fish. That's the people that would lose a lot of money. All right. And why were they losing money? Because games were being rigged and all. Let's talk about the poker games. First of all, a table would have an x-ray machine under it. So you could read the cards. And then somebody would probably be wearing like you can't really see this in my ear right now, but a little tiny ear chip where, if you had your phone right there on the cards, or somebody had their phone right, it would send a little beepy little thing. It could tell you hand 2, seat 2, seat 7 was going to be the winner, because it could read all the cards in these special poker shuffler machines that they would have. Some of those machines can cost you about $5,000, by the way. But very, very quickly. And would read the hand so that you'd have the people who were cheating that would go all in and shove all in when they were looking for an inside straight. Everyone who plays poker knows that's not a very good thing to look for, especially if you want to pay for $200,000 or $300,000. Or the person that had the trips, the trip aces, would lose, because they would know that, and they know what hand could win or lose, and that's how they cheated at poker. All right, but then there was also gambling. Not just it wasn't, because poker, some say, is a game of skill and it's not cheating.
Yeah, that's true. Some would say that. I heard that it was like 1.8 million taken down in one session.
Well, not the games I play. When I go play 130,
that's one hand for you. Come on.
I would love it. I'd love it if I were doing it on skill. But anyhow, but it gives you a different outlook. And some of my friends are saying you never go to somebody's house and play where they have a shuffler at a house, because you don't know how that shuffler has been programmed, and you could program it in many different ways and all. But then apparently players like Rozier, they'd have inside information, like, I'm going to get hurt on at the third quarter of a game. So,
actually, he went out after about 8 or 9 minutes. Couple of things about, the NBA, first of all, with all these prop bets, which you can get in all sports now, it really leaves you wide open to...
Explain a prop bet. Explain what a prop
bet is.
Prop bet
would be one player, for example, Mr. Rozier, Over or under 12 points for the night, over or under 8 rebounds for the night. Well, if you pull yourself out of the game from an injury and you had everybody bet under those various propositions, you're gonna make money. Very hard to tell when it's happening legitimately or not. It's just, unless somebody's ankle goes sideways when they hit the floor. It's just subject to that kind of abuse. Here, let me just say this: full disclosure, NBA, I could give a shit about the NBA, and here's why. When I was a sports director, and I was doing all what's that?
You were a sports director?
Yeah, the Fox affiliate in Central California.
Oh,
I
wow.
got the opportunity to interview everybody from Mike Tyson to Arnold Palmer and anybody in between. Football players, basketball players, baseball players. My favorite. Steve Young, Joe Montana. It was amazing. Great opportunity. I had the opportunity to also interview some NBA players, and on balance, they are the biggest jerks, assholes, dicks of any
Oh, wow.
figure you will find. Now, of course, that's a hasty generalization. I'm sure there's a couple of in the mix. But here's the deal. That sport, there's only, 10 players on a team, give or take. It is a very small fraternity, but how there are 36 teams. I don't even keep up anymore because I really don't care about the NBA. It's a joke. So there's a very small number. It's a very small fraternity. So they major in being standoffish and, kind of arrogant, and, it breeds assholery. And so I have no interest in them. They should go down with the ship. This betting scandal should kill the NBA. Okay. Having said that,
Having said that,
it's subject to major abuse, and I feel sorry for those who are get suckered into making these bets. They have no control over.
The interesting thing is, not only with that, this case involves, and you can't make it up, okay? If you had screenwritten this, it involves La Cosa Nostra, the Mafia, right, people.
They have their own way of, controlling the way that, and I'm fine with that, to be honest, because at least you know what you're getting into. You're playing with the mob. You could be dead. At least you're getting in with those guys.
That's apparently who their enforcers were with the mob. Now, I don't believe that Chauncey Billups was an enforcer, but apparently they were associated with the mob as enforcers. I love this story. I'd love to look more into the story. I think I could talk about this story all night, but we don't have no night. But if you want to go take a look at, just Google NBA coach player suspended after federal arrest on unlawful gambling charges. My friend Earl Burton, who wrote this article. Earl, I'm going to have to tag you on the show after I showed you this. Maybe we'll do a special one night with him if it breaks even further. The Mafia, the horses were back.
Yeah, when there's a death, then it'll be more in our wheelhouse. Okay, we got one more thing. Brian Walsh, right? Brian Walsh. Should we share this document or should we move on? I'll let you make the call.
Share the document. Share the
document. Okay.
We can read it.
Yeah, we can look at it and go, This is something. This doesn't always happen. I guess it depends on the court. Depends on where did I hide it here? Depends on the nature of the case. This is called a shared or joint statement. Let me zoom that in a little bit here. Officially assigned Judge Diane Frenier. I know that's not the pronunciation, but I'm French, so I got to go with it. So this is a statement they basically will read to the jury, right?
Right.
And it just lays out what the parties agree is the nature of the case. December 30th, 2022, Anna Walsh returned home, blah, 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 worked and lived in Washington, D.C., and will return to the family home in Cohasset, where her husband and 3 small children continue to reside. On January 4th, her employer called police to report that she was missing. So there's a bit of a gap there. And then they are not going to agree on what happened between December 30th and August 4th. That's the nature of the whole
January
trial.
4th. January 4th.
January
right?
4th, thank you. That's the trial. Cohasset police went to Walsh's home. The defendant reported that Anna was missing and alleged that she had left the house early that morning on the 1st, and he had not heard from her since. Days later, police searched a dumpster outside the defendant mother's Swampscott. I went by Swampscott the other day on the way to Salem. I didn't stop. Found clothing that belonged to Anna Walsh. Anna Walsh COVID vaccination card, towels with red-brown stains, a hatchet, hacksaw. Anything special about that hacksaw?
It had a piece of a bone chip on it from the skull, if I recall.
The defendant is charged with murdering Anna Walsh and lawfully conveying her body, interesting, and misleading investigators. Interesting. They don't mention dismembering. They just say conveying her body, even though they're going to learn
Right.
it was, you know, bits and pieces. I don't know. We don't know. That's the other thing. It's a missing body case. So
Yeah,
okay.
missing body. Can he prove the crime? Unlike this. Okay, I just wanted to show you this because I'm obsessed.
Wait, we're going
All right,
backwards
I'm,
then. What
I'm,
hell?
I'm
Oh,
obsessed. What can I say? I'm obsessed. I'll remove it.
well,
There we go.
gambling is an addiction.
Oh,
So
it's poker. It's poker. Come
so
on. It just said
so
cheating.
thing just to wrap that up. Most importantly, on Monday is a competency hearing. Remember, he was hauled away for evaluation. The trial has been moved to November 19th, but if he's not found competent when they meet on Monday, it's hard to believe that date will hold either. So we'll see. Okay,
Okay,
what
a
we
couple things
are we
before we're
done?
going to move on. A couple things.
Sure.
We did premiere this week The Hunt on Justice Serve TV for members only. And Sherry Schreiber, Missy, there you go. I'm putting Missy on. Sherry Schreiber, Linda, The Hunt on Stephanie is tough. Yes, it is. 1968 case,
Yeah.
but that's why, you all have some duties that I possibly laid out for you to start doing it because it's going to take us a while. If you are not a member and you want to search for what I think is shall we say, a suspicious death killer. Okay, that's the only way I can put it. Join membership and you'll get first access to The Hunt. And we'll see when people email me with their suggestions and all in response to my suggestions of what they do, whether or not we'll move it out to the all membership or we'll continue to have a meeting with, certain members, maybe different levels of membership. We'll see. Let's see how you all do. And also, we do have we do have Donnie Not
Thank you, Donnie.
One Justice Serve TV membership. And that leads me, please hit that subscribe, share, like, and notify button as I turn this back to Michel Bryant.
Yeah, and tonight is we understand. First of all, it's weird that we're doing a live show. We haven't been doing lives on Friday. We've been trying to kind of ease our schedules by pre-recording something, but because yesterday was a bit of a craziness, we thought we would regroup, come back, and go through some of the stuff that we learned yesterday, collected yesterday, and get into the Kelsey Fitzsimmons case on that level because we were lucky enough to be there and kind of absorb as much as we possibly could. And we've shared all the video, but there were some other things that were taking place, and we haven't forgotten that the World Series is starting at 8 o'clock Eastern time tonight. We'll be done in plenty of time for that. What we thought we would do is share some of that video and then kind of talk about it because sometimes just seeing it unfold or hearing a lot of silence, it's kind of nice to be able to look at it with a little bit of our guidance. So let's start with, let's see, what should we start with? Let's start, how about with number one? Would that be a good start? Let me see if I can find it here for you.
And while you're looking for that, we will get to the petition that was filed.
Yeah.
The brief for the petition that was filed.
Yes, the T's, the SJC on the clock. That's now they've gotten the paperwork. There will be no responsive paperwork from the Commonwealth, so they should be sinking their teeth into it, or at least we certainly hope they do. So this is
pool
Judge
camera.
Mary Black, pool camera.
This was the pool camera. This was you. You were the pool for the streaming network services.
It looks better than I thought. As I'm looking through the viewfinder, it looked a little murky, but this looks pretty good. So we'll see this a lot. This is the judge doing a lot of that. Okay, so we're not going to, there's in the gallery there. Close your eyes, Linda Kenney Baden. I'm showing the gallery. Don't look. Don't look. And I wasn't sure because just so folks know how this came together, I had made the request. They acknowledged the request, and then as I'm getting into the courthouse, they opened at 8 o'clock. I was there about 7:30 to get ready and catch whatever was happening. I see the guy, a boss, I learned his name was, from Boston 10. He's getting his wagon together with all his gear. So I go over. I said, "Oh, you given okay to do that?" He said, "Yeah, I was." I said, "Okay." So I went inside. I said, "Who do I talk to?" I made the request. I know the local rule allows one broadcast and one web-based. So here we are. That's at 8:15. At 8:21, I get the email, "Hey, you're approved." At 8:21. So it was too late to do anything to try and stream it live. And regardless of what Boston 10 may tell you, they weren't streaming it live either. We were both recording it. And so we were lucky enough to pull that together, but not enough notice to do what would have been nicer, which is to stream it live. So we'll work on that. Anyway, I didn't know what the rules were in Connecticut. It's brutal. Don't show the judge. Don't show the gallery. Don't show anybody but the participants in the prosecution or the defense and a defendant. It's very strict. It's pretty much shoot whoever in the hell you want to shoot in Massachusetts. And so you see there's Tim Bradle up against the wall right there. And this is really the row for Kelsey Fitzsimmons support team, family and attorneys. So that's what that is. Let's see. I will try to. Okay, yeah. So obviously everybody wants to see Kelsey, when she first comes in, because nobody has seen her for about 5 weeks, right?
Right.
So there's the judge looking at papers, and we're trying to get, Tim came over. And he said, hey, they're bringing her in this far side by this window that is blowing out our camera shot. So when you see us go over there, it'll be about 10 minutes, before they're ready. And the judge did something which I appreciate. She said, I'm going to call the next 3 cases in this order: Smith, Jones, and Murphy. So you kind of know, it's like baseball. Who's on deck, who's in the hole, who's batting. And so I think it's great for the attorneys to be prepared that way. And it was great for us because we knew we were just hanging out. And she pushed this case to the end. And it was full only for this case. There's no doubt about it. People were coming into this probate and family court going, what the hell's going on? Because they never see the place full. It's usually a sprinkling of people, a lot of attorneys just making appearances to get this conservatorship document done or get this visitation document. It's very administrative, right? There's not even a witness stand. So you'll see when the judge swears people in, they just stand at the table. So there's the man, Justin A. You can fill out the rest of the letters. Okay, moving on. That, of course, is Julie Hess, the new attorney. And here comes Kelsey. And then we have Julie Hess blocking her for quite a bit of this time. I thought she looked pretty good. I'm looking at it from the outside. I have nothing to compare her to really, but she seemed pretty good to me. Thoughts?
Right. No, I thought she did too. I thought she looked pretty good, and I'm sure she must have been buttressed in how she feels, because part of looking good is also how you're feeling, and I think she must know that she has support out there, and her family's behind her, and there's people behind her, and I think that's probably a very good feeling. Plus, remember, she's seeing the light of day. We talk about this when we deal with other defendants. She's seeing the light of day. Right? Yeah,
that's true. When you're in the hole, and let me get to that in just a second. Yeah, you're right. She's taking a nice little tour across the state of Massachusetts, probably looking at it in a very different way than she has before. So I'm talking to Stephen Fitzsimmons outside the courthouse. That's her natural father. And I'm, how's she doing? What's the deal? She's not in general population, which I felt was good, especially with her history as a correctional officer and a current police officer. She's basically in solitary, but they don't call it that. I guess it's some sort of protected custody, protective and protected. Right. So that was good. He said she's first thing he said was she's tough. She's tough. She used to be a correctional officer at a facility with 110 men. Okay. And so she's got to be tough. Now you see her, she's 5'4", 100 pounds, maybe dripping wet. So you got to be tough because your presence is not so tough. So he felt that she was handling it as well as she could. He talked to her a number of times on the phone, had not been visiting, and it sounded like they weren't allowing it. And maybe that's because of the nature of the custody. I don't know. It was a little unclear. And he said, we know that, at least I saw a print article with the stepfather, Will Page. I think they spoke to Will Page and Laura, now Page, the natural mother, who I also saw there, did not get a chance to talk with her. But both of the fathers, Stephen and Will, came up at different times. Stephen before the matter began and we chatted. they were expressing their gratitude at what we're doing. They've been watching us. Stephen said, I was watching you here last night, meaning the night before last when I was at the courthouse. So they appreciate all the support that's being offered to their daughter. And I said, make sure you keep us posted on how we can follow through with our promise to take care of her monitoring needs after she's released, whether it's an ankle monitor through Scram, whether it's alternative.
Rise and identify yourself, beginning first with you, ma'am.
Good morning, Your Honor. Tyra Cameron on behalf of Justin Elaine.
Thank you. And sir,
Justin Elaine.
and counsel,
Good morning, Your Honor. Peter Kuiper for Justin Elaine.
and ma'am,
Good morning, Your Honor. Julie Castle, Kelsey Fitzsimmons.
the last name? Thank you. And ma'am,
Good morning, Your Honor. Kelsey Fitzsimmons.
thank you. And counsel,
Good morning, Your Honor. Ryan Leonard for Kelsey Fitzsimmons.
thank you. Would the parties please raise their right hand? Do you solemnly swear the testimony you're about to give in the cause now in hearing will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes.
Sir?
I do, Your Honor.
Thank you. You may be seated. I'm reading the affidavit that was provided by, not the affidavit, the memorandum that was provided by counsel for the plaintiff. All right, just one moment.
Yeah, it ain't one moment. So you don't really hear much more
Did I
from.
fail to recognize another attorney?
Oh yeah.
Hello, Your Honor.
Yes,
Timothy
counsel, I'm
Bradle.
sorry. Your
That's
name?
all right. I'm criminal and restraining order counsel for Ms. Fitzsimmons.
And your name again?
Timothy Bradle.
Thank you.
Thank you, Your Honor.
Okay, hold it. See this woman right here, this bailiff right there on the
Yes.
screen.
Yeah.
Last name Bryant.
Oh my goodness, is it a
Yeah,
relative? Did you check?
she came over and said, "You're Michael Bryant." I said, "I'm a Bryant," and so we had a bonding moment there.
Did you take DNA? See if it's
Yeah, I said,
genealogically
"Well,
related?
we're related somewhere, somehow. I don't know." So we're not going to hear much more from Kelsey Fitzsimmons, and I'm going to zoom through this part. People were so mad. I was rushing to get this posted, and it was done in 2 chunks because that was the nature of the way the camera recorded it. 30-minute chunks, and then there was 15 in the second part. And I just want to get it up there, right? And so it's 20 minutes of this. So people are like, what happened? I tried to put it in the notes. This is raw. There are a lot of pauses. Don't get your panties in a bunch. And so I did some panning around. Don't close your eyes, Linda Kenney Baden, showing the gallery. Let's see if I can point out anybody that people might recognize here. Let's see. All these folks sitting in front of the rail. Those are just the local yammering attorneys.
They're having a great time because they're on TV.
Yeah, somebody coming up you might recognize. Did I go far enough over? Come on, where is he? Come on, there he is. Who's that? Anybody know?
That's the Young Jerks.
Mike Crawford. Yes.
Mike Crawford, yeah.
Yeah, I asked him. I'm always asking the insightful, penetrating questions, and I asked Mike. I said, "It's Young Jerks, plural." I said, "Is there another jerk floating around that I'm unaware of?" And he told me the whole backstory, which was he did have another partner at some time who at some point decided to leave the broadcast, and it remains plural jerks, but there's really only one jerk. So I'll tell you the busiest guy. He just kind of moved through the shot there. We'll probably see him again. He's the clerk. Let me see. I'll just give him his due here. This guy right here. Where is he? Not him. Not him. Not him. Here, he's going to come shooting across the shot. Get ready. And he's in a hurry at all times.
Oh, there
this
you
guy.
go.
This guy right here. He is. The judge would ask each litigant, "Do you want to wait for the order, or do you want to have us just send that to you?" "Oh, yeah, Your Honor, we'll wait." This guy is banging stuff through as quickly as he can for these various orders that they need, so they can get them in real time and not have to wait. So he's back and forth all over the place. Okay, so let's get through this large amount of quiet. Let's see if we see there's a more open shot of Kelsey. And that's Julie Hess conferring with Bradle, basically. And from what I understand, that this gentleman here on the far right, that's the Commonwealth attorney. Or I'm sorry, that's Justin's attorney. So used to seeing defendant and prosecution. That's the attorney for Justin. He had 2 attorneys there. They worked all this out between Julie and this guy, whose name I can't remember. He identified himself, and I forgot. So that's what they issued to the court what's called a proposed order. It's effectively a stipulation, but if you have it as a proposed order, you're waiting for the court to rubber stamp it. Or not. They don't have to. I went to get a copy of that. I was asking Tim after the interview was done on the courthouse steps. I said, "You guys have filed that?" Because he kept calling it a stipulation. And he said, "Yeah." And I said, "Is it filed under seal?" "No." Great. So I get done. I go in, see the clerk. "Yeah, I'd like to get the stipulation that was filed just this morning in this case. Here's the number, blah, blah, blah." "Oh, I see proposed order." I said, "Oh, that's it. That's it." She looks, said, "I can't give you that." I said, "It's not a public document?" "Well, no, it doesn't have a docket number." I said, "It was filed, right? It was filed." "Yes, it was." I said, "Well, something's wrong here then. Can I talk to the registrar?" So they bring the registrar out there. I was like a Karen there at the counter.
Tell people what the registrar is.
Registrar is the county official that administers the whole probate, in this case, the probate and family law domain, documents coming and going. They're the ones that make sure everything's done legally and properly. They're in charge. So she comes out, very friendly at first, and then I start questioning, well, if it's been filed, a document has been filed, I understand I can't take it and whip it around like it's a court order. It's a proposed order. I get it, but it's been filed. What statute? Give me the Massachusetts. I said, I'm not a Massachusetts attorney, but I'm pretty sure there has to be a statute that requires you to keep that from the public when it's not sealed, it's not impounded. And she won because she's got the document, and I just there was nothing more I could do.
You don't have a title.
Yeah, I mean, all I have is this document listed in the docket, and that's it.
Yeah.
So the key to that is they wouldn't talk about it in the interviews after this hearing because they don't want those specific details out there from their mouths. If it comes from the court, you get the document, good for you. But until the court sees it and signs off on it, they didn't want those details out there. And I was trying to work my way around that, and I was thwarted. So, okay, let's see how much more of this is happening before nothing. It was interminable. Yeah. It was just.
And before you go to tape two, I have something ready for you too. But I know
okay.
it was a long time coming, and I kept going on the stream too and saying to people, finally Missy pinned it. Hey, look, we told you above. This is raw footage. If you wanted to see it, and this is what it's like to be in the courtroom.
It is, and that's why I said, hey,
it's like to be in the courtroom.
Enjoy. This is like real court experience. This ain't Law and Order. Dun
right.
Dun. No, it is not.
And also here, remember, Kelsey's in the courtroom. She doesn't mind being there, okay, for this period of time. Let me tell everybody that. Also, you got to see Justin in the courtroom. You got to see his father was there with him. You got to see they were looking at each other. You got to look at how Julie Hess acts.
See, like where Kelsey's turned around facing back. She's like, she's basically communicating to her supporters, her family, and others, just if nothing but eye contact. Okay, so now we're back doing something.
Counsel relative to the plaintiff's memorandum on the issue of venue. And have counsel had an opportunity to confer regarding this issue?
We have.
We have, Judge. I will say this is the first time that I heard the issue this morning when my brother submitted the memo. But we have conferred, and I'm gonna let my brother go ahead and speak.
All right, very good. Why don't I hear you, counsel, on the issue of venue?
Thank you, Your Honor.
Okay, before they get started, you probably heard Ms. Hess call him brother, my brother, brother, and there were comments saying, "Are they really brother and sister?" No, they're not. It's just a professional courtesy. Right. I don't see it very often, but in Massachusetts, where they do cling to a few things from the old world, it happens. So, have you seen it much in your practice?
No, but I've seen people refer to me, my sister at the bar, my brother at the bar, and I've had that happen over the years because it's kind of like an old time. It's from England, when they say
it is. Yeah, and they do cling to that there. I would normally, say, colleague or, something like that. But anyway, so yeah.
My hated adversary.
My learned adversary. So for
those learned adversary is a big one. My learned adversary. No one ever says my hated adversary. Okay?
No, and there's no other kind of colleague but an esteemed colleague. There's not an unesteemed colleague. So for those who are concerned, no. is not a family gathering here.
Praise the court. And Your Honor, likewise, as my sister has said, I also sort of heard about this issue rather recently, and when we had filed the motion to advance the hearing to today, candidly, the clerk's office had said, this may be an issue, so I took a look at it. And, my client had filed a complaint pro se, and at the time, I know on the face of the complaint, Judge, it was completed with the assistance of the Court Service Center in Lawrence, and an issue of jurisdiction had been raised. At the time, there had been a series of events that happened very quickly, and at the time this all happened, he did live in North Andover, the child lived in North Andover. The restraining order came, I believe, the day before that, and he did move
In June.
June 30th. Yep. And he did move to his parents' house in his mind temporarily, not knowing what was going to happen. He did write down that he lived in Stowe. He remains living in Stowe today. The statute talks about where one parent and a child lives. Technically, Ms. Fitzsimmons continues to reside in North Andover. Technically, the child could be construed to have lived in North Andover. I think the statute's satisfied. That being said, I'm not married to the notion that the case has to stay here or transferred to Middlesex County. I'd be okay with that. I think it's an interesting issue. I think it's a close call. I think the court made the determination, my sister really hasn't done that. I gave it them this morning. I think the court made the finding that.
Hey, yeah, Missy, I'll ask if you can, if you can bump the audio up at all. I'm kind of maxed out here. I don't know if you have the opportunity or the ability to do that, but yes, it is low. I'll bore you slightly with the audio setup. They wouldn't let us put our individual microphones up where these mics are. See these mics at the table? They wouldn't let us put them there. So we are on a table to the side. And the idea was, according to the clerk, everybody talks into their microphones and it comes out of these little speakers. So you just put your microphone by these little speakers. Nobody's talking into the microphones. They're all feet away, except for the judge, because she's right there. So that's why the audio is lower level than you might like. That's all I can tell you.
At the time the case was filed, the child technically lived in North Andover and not Stowe. Mother still lived in North Andover, then the statute is satisfied. It's definitely an interesting issue.
So
based on a matter of a day.
You indicated in the memorandum that your client left North Andover and then pretty much immediately after securing the restraining order and went to Stowe. Is that correct?
He did, but he also had belonging. Everything was in North Andover. He was paying a lot of bills in North Andover, so he was in both. But he was, to be forthright, he was living with his family in Stowe.
Mm-hmm.
Okay, let's talk about what's going on here. And I apologize again for the audio being a touch low. If you've played some of the raw, obviously you can adjust the volume to your liking, but within our StreamYard system, we're maxing out. They get in there in the morning, and I get the feeling even Justin A's counsel wasn't really clearly aware of this, but Justin A filed this pro se, the original document to get the baby back, right? They did that in North Andover, which is a different county, Middlesex County, right?
Right.
And then he tried to immediately change that to a new address. He changed his driver's license. He changed his voter registration, which I think is tied to your driver's license in Massachusetts. His credit cards, everything but his job. He moved out of North Andover, and now they're trying to say, well, then this matter doesn't belong here; it belongs elsewhere. And this judge is now caught saying, well, do I even make a decision of any sort on the merits of this case if it may not stay here? Which I think everybody would agree that'd be a waste of judicial effort and everybody else's time and preparation. So Julie Hess is asking for a week to flesh this out, to come to a decision so the court can rule. The court said, fine, I won't have to bring you back. I'll do that administratively. Okay. That's what she's fleshing that out now by asking a number of questions about what he's done or hasn't done to, quote, relocate.
What did he take with him?
And just for the moment, there is a question here having to do with, like, in some states, since this doesn't involve a child involvement, you wouldn't, like in New Jersey, see any of this, which is true. But I wanted to point something out about this judge. She had she represented as a guardian ad litem. I mean, the court appointed a lot of times to represent children in this kind of situation. So she's really a good judge when it comes down, if we get to that. And that's why you're going to hear her also ask these pointed questions with regard to where things are filed, because she knows that law, and everyone should understand that.
Yeah, and it is a very special area of the law. There's, it's not like you come out of law school being an expert in family law because you took, a semester. And it was not just, the diligence she used. I was a little surprised she wasn't a little better prepared, especially for this case, knowing it was coming. But she took the time that she needed to feel comfortable. So all that dead air that we suffered through was important for her to figure out what's going on in this case, and especially now with this change of venue idea. I thought it was sandbagging. I asked Julie Hess that question. It came out of the blue, and it just looked like it was prepared and yet never shared. You don't make all those changes to your life connections, right?
Right.
And then keep that quiet till the day you go to court. Well, why would you do that? Not that the changes themselves are unusual, because he's going through some life changes, right? He's living with his parents, and the baby's with him and them. So those kinds of things are life changes you would expect. Well, why are you hiding all that and then dropping
Well,
it on
because he
them?
was going ex parte for that order. That's why. And he didn't want to share anything with her and give her the heads up.
Yeah,
We all
and that's
know what was going on there.
that's my point. And Julie Hess was too nice to label it sandbagging, but she did reserve the right and is rebriefing it. I know they changed the dates, which we can get to later. They didn't go for a week. I think it's a few days. Why? Because the House is about to close. It's supposed to close, I think they said, on the 3rd of November. And so there became an issue about, well, can't they extend that? And the judge is like, talk about not knowing a certain area. I've done a little real estate law, and as a broker, I know that it's different state to state, contract to contract. You don't just get to extend the
Right.
closing date just for the hell of it.
Right. And also,
Everybody's
there may be a
pounding on
mortgage. There may be a mortgage tied to
there
it.
may be a
that-
mortgage. I
Right.
mean, people are, I got my people, we're moving on this day, and you can't just push that a
No,
couple of
yeah,
weeks,
push
would
that
you?
is right.
Not without consequence, anyway. So she didn't really know that. Can't you just push that? Because her hope was to get this venue thing resolved before the House closed, so that they'd be in the right court for whatever she decided. I personally think there's going to be an escrow account opened. They wouldn't confirm that's, after the fact. I think there's no better answer. How do you not put it in escrow at this point and then fight over those proceeds? I don't understand how you do anything different.
We took some clothing, temporary, just some items of clothing, items for the baby, some personal effects, but he had to go back. I don't know what he did over there after to retrieve other things. It was a temporary. In his mind, he didn't know, honestly, Judge. At that point in time, he didn't know what was going to happen. He didn't know where things were going to end up. It was a very tumultuous period of time.
Does he have a vehicle?
He does, Judge.
Where is the vehicle
Let me ask you.
cited as being registered?
It's registered in Stowe, Massachusetts now.
And when did you register
Now.
it?
Yeah, everything's in Stowe now.
2 months.
Yeah. When the 2 months? Were that after or just the
And
same
your
time?
bills, where do they go to?
Uh-oh. What is looking at him?
Currently, or is this at the time?
At the present time.
Present time, goes to Stowe, Massachusetts.
So credit card statements and all those types of things go to what location?
Correct, I have transferred everything over to Stowe.
All right, so all of your, mail comes to Stowe, is that correct?
Yes, my mailing and billing address is now Stowe.
And now remember, he said that was 2 months ago, and he's had the baby for 3 months and told nobody about this transition.
Right. And the question is, when did he fill all this forms out? I mean, it just sounded like he was sandbagging her. He didn't want her to know, and obviously, of course, he didn't want her to know. That's why they came in and took the baby, and leading to this whole horrible situation.
Because I note on the restraining order that paragraph 3 lists the Stowe address as well, right?
That is correct. Within a day or so, I had moved back home temporarily, not knowing what was going to happen with my son while that tumultuous period was occurring.
All right, Michael, stop it right there. That's
Okay.
the question. She got the question right there, and he said, "Well, I put it on there because the move about it was going to be temporary, not knowing what was going to happen with my son and all that, so I put it on there." but he gave the address to Stowe. So either he was living there, he planned to live there, he
That's his
wasn't living
parents.
there.
Yeah, that's his parents.
Right, and that's
Can you
where this whole-
imagine? I sit here and I look at this, and I imagine Leslie Fitzsimmons. What's going through her mind with everything he says, right?
Kelsey?
Knowing what Kelsey, knowing what put her where she is, knowing that her son is now with this guy, and every day that the son is with this guy, makes it difficult for her to re-engage.
Right.
And
this guy is the guy, though. Let's remember, she was going to marry in October this month.
Mhm.
She had picked him. She was going to marry him. I mean, you can't make this up, except that
It's
for
just
TV movies.
we're not even talking about the merits of the case. It's just the brutality of this interim period. I would not be nearly as upset if she was out taking care of the baby and preparing for whatever that trial was going to look like or whatever the resolution was going to look like. But this interim, situation is it's just tragic.
So, did you change your voter registration status?
I did, yes.
See, now I know a lot of lawyers who'd play hardball with this right now, Michael.
I believe
Okay.
that was changed over.
I know a lot of lawyers
On
would
which
play
side?
hard-
On the Kelsey side?
Yeah, on the Kelsey side. Now they want to get the obviously she wants to get the baby back. She wants to get out. They don't want to do anything that's going to upset that apple cart right now while the SJC has this. But I know a lot of people that would go after him. Okay, so where were you living? You said you affirmed under penalty of perjury of law that your address was your domicile. Your domicile was Stowe on that date that you filed for the restraining order. Weren't you home? When did that domicile change? I mean, right down to the second, because it's something doesn't smell right, right? So I know a lot of lawyers, when the time comes, and it may not be right now because she has to get out of jail, but it may be soon, as to, wait a second, you were a firefighter and you, the lawyer would say, prevaricated on your affidavit?
Yeah. Or you didn't, and then you were hiding all this other information. The question that came to my mind immediately was, well, aren't you still working for the North Andover Fire Department? And the judge ultimately got to that question, and she even said, well, do they have like a rule about how far away you can live from your district? And it's 20 miles. He's at 22 and a half miles, so he had to get a special dispensation from the fire chief and whomever else to do it. But the point is, he's got pretty significant contacts still in North Andover because he's working there, as a firefighter.
When I did my license, that was within several weeks of leaving North Andover.
And that was my next question. So your driver's license indicates Stowe, right?
Correct, Your Honor.
Okay.
Okay, so then my camera decided to take a break. Said 30 minutes is plenty for me. How are you? And so I don't know, I haven't.
Missy's got the segment too. She can play it because she can ramp up the sound. Okay.
Oh, cool.
But
Do
in
it.
the
You
meantime,
got
while
it?
she don't do it yet. Load it, get it ready, because let's just show Michael Karmadharma, who the mug will be on the way as soon as you send it to Karmadharma. Won our last Where in the World is Justice. Michael, what do you know about Justin's dad?
Not a heck of a lot. He was there with him, came in with him when they came up the steps and ignored me. But I have not researched, don't know much about him. I know that Kelsey's dad is in electronic security, is how he described it. But Justin's dad, no clue.
And then Kay Schmidt gifted 5 Justice Serve TV memberships,
Kay
which
Schmidt.
is great. Thank you, Kay Schmidt. People can help. They probably already began out. People can go help immediately on the hunt immediately after we finish our show. Let's see. And we saw this, Denise. No,
I didn't. You mean in court when I was trying to figure out which way to point the camera?
Yeah, that's good. I can't wait to see that. You can post it on X and tag us. Jane Treed 5701 gifted another Justice Serve TV membership. Thank you. And then as Missy's loading, getting that ready. Hey, Paul, no more Fashion Friday. Well, we're going to do just a second, a little Fashion Friday when Missy's getting that ready. Remember I told you that I've been going to a bunch of birthday parties, right? I actually had a dress. No, not for me. They weren't for birthday. I actually had to dress our birthday boy in this party yesterday. You see how I dressed him? He had he had
Is that
I'll keep his name anonymous, right? This is Fashion Friday. I'm actually dressed over here in a Dolce & Gabbana
I
coat.
can't. Oh,
Yeah.
okay.
He's actually, well, the reason why you can't see him is because I put those little things under your eyes that you have to wear, and then I put a COVID
Oh, I
mask on
see.
him,
He's got a
and then
mask and he's got a
on him.
shield. Okay.
You know, shield.
Okay.
And then later on, he was wearing Tom Cruise sunglasses under the mask and the shield, and a T-shirt over here. He's dressed, and he was dressed to make wine and all sorts of stuff. So this kind of is Fashion Friday. This is how I was dressing people as I was doing my presentation. That's a Millennium Falcon, by the way. You can imagine he is a pilot, so that's why he was getting.
Okay, it's all making sense.
It's all making sense. And while I mentioned that to you too, as Missy's about to load this, one other thing, we will be this Sunday. We have a tea with Jack the Ripper. All right, and it's actually questions that were made by Dr. Peter Dina Coroner for this birthday party last night from London. And we're going to give those questions to our own Michel Bryant. We're going to let him take that test. So you can come along with us when we post this on Sunday and take that test too, to see what you know about Jack the Ripper. And usually when we have somebody that we don't like as a defendant, we can call him Jack. Okay. I'm back.
Okay. All right then.
Now we need section 2.
I don't know if there's any audio here or not.
No audio coming out, Missy. If we boosted it, it's not coming out. That'll show me in a minute. Jersey girl Trey, member for 6 months. All of his actions were premeditated, terrible. Married D2D, member for 1 month. Thank you, both of you, becoming members and giving memberships and posting it. Okay, so let's see how this works. If not, Michael, we'll go back to you.
Yes, sir.
There we go.
Let's go.
And relative to the child's pediatrician, is that in the Stowe area?
The pediatrician is still in North Andover. I stuck with the same one that he started with. He did recognize the fact that it is a bit of a drive to bring the child up in case there was something that did arise. So I have thought about changing closer to Stowe, but he currently is in North Andover with the same pediatrician.
Okay. Anything further, counsel?
No, Your Honor.
Do you wish to be heard on that, counsel?
I do, Your Honor. Thank you.
damn
I would
straight.
ask the court if I can have 1 week to brief this issue. I do think it's an interesting issue, as my brother counsel indicated, because the father technically resided when he brought both restraining order and this action in North Andover, as did the child and mother. Mother's residence, as Your Honor probably saw from the filings and the stipulation that was submitted today, that her house is being sold, but where she plans to go upon release from jail would be also in Essex County in Methuen, where her parents reside. The fact that father made changes to certain bills after he made the filing, I don't think is necessarily indicative of where proper filing is. As my brother indicated, I also don't necessarily have a preference, but I do think it needs to be accurate. And so I would ask if Your Honor would just give me 1 week to flesh out some of these facts so I can understand them a little bit better, because I do think that some of the, on the face, the paperwork says it's Stowe, but even in the memorandum submitted to Your Honor this morning by father, it says that he is in North Andover, or felt that he was in North Andover, wants to carry on in North Andover at some point in the future. So I would want...
May I interrupt you for
yes,
one
Judge.
moment? I just thought of a question. Is your client still employed by the same employer that he was at the time of the incident?
Yes, Your Honor. He's employed at the time of North Andover.
All right. And is he permitted to, if you're able to disclose this, is he permitted to reside in another area and continue his employment at his present employer?
I believe so, Your Honor.
Yes, Your Honor.
Okay. Was there a need to get a special allowance, or would the permission have existed regardless? Like, do you have to work within a certain
Permission was
radius?
granted by the town manager and the chief of the fire department.
Okay.
Since I'm 2.5 miles outside of the 20-mile radius.
Okay,
But permission was granted by both.
thank you. And you may continue, counsel.
Thank you, Judge. I was just suggesting that if Father really does intend to return to North Andover as his filing this morning suggests, what I wouldn't want to have happen is that he transfers it to Middlesex and then all of a sudden everything comes back to Essex, if you will, Judge. I do think the continuity in a court system for this type of case is important. I also do recognize that, as my brother indicated in the note this morning, there's so many other actions that are here in Essex County. I don't think that's necessarily defining, but I do think it's important for this court to consider. And so, again, I would ask for a week to brief this and submit that to Your Honor.
All right. And do you wish to comment on that, counsel?
No, Your Honor, it's my sister, and I have no objection to her having an opportunity to brief it. Likewise, I'd like to do probably a more thorough job. This together very quickly based on comments from the court.
Yep. This is what I'm thinking. I think that is a fair request on your part, counsel, that you have an opportunity to exercise your due diligence and brief the matter. So I'm inclined to allow it. What I'm thinking of doing is giving you a period of time and then giving you a short period of time for a response written. And then I think what I'll do, rather than scheduling another hearing, is just act on it administratively, because I've heard your arguments, I've heard, some of your argument and understanding that you wish to provide me with something more formal, so to speak. So I believe that that is reasonable. Would either of you be opposed if I then elected to act on the matter administratively and issue my decision at that point?
I would not object to that.
All right. No objection. Very good. So let's take a look at the calendar here. When do you think that you can have the brief in, counsel?
I can have it by next Wednesday, Your Honor.
All right. And that would be the 29th, right?
Yes.
And what time frame, counsel, do you believe that you would need the...
A few days, Your Honor. I don't think it would take that long.
So
at the court's discretion, a few days would be fine.
So I'm thinking maybe if you could have it in by the 3rd?
That'd be fine, Your Honor.
And Your Honor, because my brother counsel and I have already spoken about this a little bit this morning, we actually might be on the same page after the two of us do more due diligence on this. And if we are, would Your Honor like a joint memorandum to report?
If I'm happy to accept whatever you wish to do. And the other thing that I'm thinking, I'm just trying to think of a mechanism so that we don't have to have everyone come back in again, because I noted that you had submitted a stipulation. Is that correct?
Yes,
and without going into it substantively, did it address all the issues, or were there certain issues that needed to be addressed?
So our stipulation, Your Honor, that we worked on over the past couple of days addresses all of the issues that are before the court today on 2 motions filed by the father.
Okay.
So all the issues before you today are resolved.
And in the event that I was to act in a manner such that this county retained jurisdiction, I'm wondering if counsel would be comfortable with a written colloquy of the parties, that I could then act upon the matter administratively, or would you want it heard when I actually acted on the motion?
I'm fine with it being written, Judge, but I would have no objection to going forward with stipulations today. The parties are in full agreement. There were 2 motions that were submitted on an emergency basis. And part of that is because of the sale of the house.
And when is that scheduled?
November 7th. Correct, November 7th.
No, I mean, if we're operating on this time frame, that would all, I can meet that time frame. I'm hesitant to take action on something that I may be sending to another county, so to speak, but I would be able to act on that and meet that deadline so that you would know what the status was, at least from this court. If it is in the event that it is transferred to another county, I'm assuming that the purchase and sale agreement probably has an extension clause worked into it, right? So it would be, most purchase and sale agreements have that,
So Judge,
yeah.
There is no extension clause.
Judge, if I may.
Really? Was it stricken? Generally, there's a standard. Yeah, I mean, I could be wrong, but my recollection of purchase and sale agreements is there's usually an ability of the parties to continue it out for a period of time.
Your Honor, if I may, I think my sister sort of hinted at this. Today, we do have an agreement on some temporary orders, that's all they are. And
Right, but if I do that, then what I'm doing is I'm starting to make substantive decisions, and then if it's transferred somewhere else, I'd prefer not to do that. That's how I'd prefer to handle it. Counsel, did you secure any further information?
Your Honor, I'm not real estate counsel, but I'm hearing that it's not a traditional kind of a boilerplate clause that allows the parties to extend. The purchaser has a full advantage on that, and it does create some jeopardy for the seller.
Well, we can try and shorten the time frame. I want to do my best to try and accommodate the circumstances of the parties, but I'm not inclined to start making decisions. So should we try and shorten the time frame?
How about yes?
We could say the 28th for mine to be due. It's just, I would, and I know that my brother counsel and I can work collaboratively, but I would need some information from his side in order for me to be able to brief that properly, because it's all about where his client resided.
Is that something you think you can do today while you're both here?
Sure.
All right, so we'll back it up, and then you can, if you have yours on the 28th, then you can have yours on the, do you want to say the 30th?
That's fine.
I'm not sitting on the 31st, but I can have it out to you, so that at least it would be the beginning of the week.
To be clear, Your Honor, my client wouldn't, however the court decides to
Yeah.
whether the case is in Essex County, Middlesex County, we would not be objecting to either way. We would abide by whatever the court decided as a jurisdiction. I don't think it's an issue that, I think it's an issue that definitely can be resolved.
Have the two of you discussed it at all?
A little bit, yeah.
Okay. And you provided me with what your thoughts are relative to venue, apart from any research that you want to do.
Correct. Correct. I do think, as I indicated, that if, father resided in North Andover at the time these were filed, even though the filings say something different, I think it's really about finding out that fact, which is very important. And also where, my client is residing in Essex County, and it sounds like father is inclined to return to Essex County.
That's where the information that I was provided relative to changing his license, changing his voter registration, those were in some of the issues that I wanted to understand before I made my decision. Let's try and do that. And if you get it in as early as you get it in, you can be in contact with my judicial case manager, and I'll do my best to address that as promptly as possible.
You actually email those to?
It would be helpful always to, send them to the registry, but given the urgency of the matter, I'm happy to have them sent to my assistant judicial case manager so that I can have them immediately, because it does take a little bit of time for the paperwork to go from point A to point B. So why don't we leave it that way, all right? And I'll do my best to accommodate you and get that out to you as soon as possible.
Thank you, Judge. There's two other housekeeping matters. And
Yep.
again, given what Your Honor just indicated about the rulings, we had filed an answer counterclaim and a sent it to motion to accept that filing late. I was going to ask Your Honor if you would enter those, enter it as an allowed motion, but I'm not sure how Your Honor feels given the venue issue.
Do you wish to be heard on that?
Your Honor, my sister filed a motion to file late answer, so I've assented to it. I have no objection to that. I'd also want to add, Judge, the court had referenced it very briefly relative to the stipulation in written colloquy, in anticipation of what the court may decide. May I suggest that we do submit written colloquy to
I'm happy to take that so that we don't have to find a time that everyone. I am hearing no objection relative to the issue of the late answer. I'm happy to allow that because I don't necessarily, I'm not concerned about that, so I will allow that. The other issue, you're going to give me your memo on the 28th or sooner. If you get it to me, sooner, just make sure that we know, that my assistant judicial case manager knows. The same for you. The earlier you get it in, the earlier I'll act on it and get it out to you administratively. All right?
All right, Your Honor, thank you.
Very good. And I think that we're set because the only other date that we would have is the restraining order date.
Yeah, this case is actually set, Your Honor, for a pretrial conference on May 1st.
Okay, great. Very good. That concludes the matter for today.
Thank you, Your Honor.
Okay, there you have it. Kelsey's.
Hold for 1 second. My assistant judicial case manager may be out the beginning of the week, so I just want to make sure that we have you send it to the person that can
But
get
we're
it.
not finished, by
I'm
the
going to
way.
have
We're
you
still
send
gonna go
it to
through
Attorney Haddon,
paperwork
our
that's
judicial
been filed
case
today
manager,
in this
and then she'll
Supreme
get it to
Court.
me. All right?
All right, thank you.
Very good. Thank you very much. That concludes the matter for today. Thank you.
I'm glad she said don't give it to the register because, based on my experience, it may never get properly filed. We're going to skip the register and go right to the clerk.
I think Missy has to clear out that because now our sound.
Oh yeah, so we're going to bring our documents on here.
Yeah.
So anyway, there's right there. That's her dad. That's Stephen Fitzsimmons, the guy that was just walking. He's just walking past the pillar. He was sitting in that front row with her. So yeah.
So Missy
Anyway,
will close that out. In the meantime, Captain Red Snuggler became a YouTube member. Thank you. You'll be able to participate in the hunt. And so we'll finish up talking about this. We still have to talk about the paperwork.
we'll do that real quick. Because it's
not too quick. It's important.
got a lot of repeated arguments in it. Remember what this is the SJC single justice denied the appeal. That was then reappealed to the full panel minus Justice Dewar. She has to recuse herself. So that's the 6 that remain. You could only file a maximum of 10 additional pages because the underlying paperwork that the single justice reviewed will be moved to the full panel. Some folks will just say, we're good with that. And others will. And today we've had issues with her microphone.
I see. Joyce, we've had microphone issues. Let's see. I'm going to.
Yes, Sophie, that's a good question, which I thought I just answered. The single justice is normally on the full panel, but if it's the single justice being challenged, then they are recused, and it'll just be the 6 remaining justices that will look at all the paperwork. So Tim Bradle's office did file eventually. It just got filed. Was it late yesterday or early today? The supplemental documents that they wanted to bring into the mix. So we can look at those.
Well, it's certainly definitely released now. Everyone says now they can hear me fine. So I just checked the settings.
I'm not a fan. I'm not a fan of your phone. I mean your microphone, your new microphone. I don't like it.
Well, wait a second. Before you do that, Michael and I have this little thing going on. There you are.
Oh my gosh.
It's posted and tagged. This is Denise Cuisine's picture on Instagram. There's actually like a little YouTube. There's a little clip that goes along with it. Adjusting your camera. What are you carrying around? That camera must weigh 7,000 pounds.
You know what I love about this picture? It makes it look like the broadcast camera from Boston 10 is mine, but it's not. Mine is like a dot in the foreground. I can't even see our camera. I have camera envy.
I tell you what, this is really a great picture.
That's so funny. Because it's not. In fact, Do I have it here? Oh, I left it. It's still in the car. I haven't unpacked everything. It's about this big. The camera that I'm using, about this big, and that is the normal broadcast type camera that you see there. So
Tubi, by the way, is very upset with all this. By the way, all of you have been so great. We did get someone who wrote into Justice Serve TV about a possible alternative, but it still requires Kelsey Fitzsimmons to blow in it. And I'm actually looking for the page I sent you on it. Missy has it too. Hold on one second. Oh, of course, SoberLink. It's called SoberLink, but it is a small breathalyzer, and you still have to blow into it. And I know you have a breathalyzer.
I have one, a commercial type. The one that you're talking about that other company had. I don't know that they're approved through Essex County or not.
They are. They're approved in Massachusetts.
Yeah, but Essex County has their own thing. Yeah, it's still a blower. So what's the point? Because these, this is a little one, but they still require.
Can you blow into that? Can you blow into that?
I'm trying to answer Chloe's mom 412's question. Can you please repeat what Julie has asked the judge at the end? I'm trying to remember what she asked. She said she had a couple more housekeeping matters. Do you remember what she said? I don't remember specifically.
No, I don't remember. Apparently, maybe the collar that's causing my microphone to. So I am now going to put it on my jewelry. Is that better, everyone? I don't remember exactly what she said.
Yeah, it was a couple of little housekeeping matters that were relatively insignificant. I'm sorry, I can't remember the specifics of that.
Okay.
So anyway, appreciate you taking that picture.
No.
Yeah, you know, that's how loose they are in Massachusetts. In this court, you know, you can take a picture from the gallery. That's, you know, sometimes that's, or maybe we've just outed you and you're now going to be arrested. I'm not sure. So.
No. Okay.
No.
Anyhow, but the arguments actually are pretty interesting because it does talk about how the judge walked off the bench, ignoring counsel's argument for reasonable accommodations, alternative testing means that urine testing, and less restrictive terms under her release because she's a non-dangerous. Hearing about a non-dangerous offender, which apparently, as we know, the judge was like, she's dangerous to Noonan. Okay. Thank you, Judge.
Yeah, to the community. Yeah, right. And of course, Noonan is shaking in his boots because he had to shoot his friend, Billy.
And on page 3 of the 8 pages, which I don't know if we've loaded on page 3, I think I did. Really
I got it all.
You have it all. It's important to see because there is a request. There's the petition.
This is the first page. And this is all pretty basic stuff. I think I can probably move on to the second page. Introduction just talks about the basics, talks about Rule 221, which is the rule saying you can appeal to the full body, minus the single judge that did you wrong. Okay, and now I will, hold on, let me find the next page. That's the problem with grabbing this kind of piecemeal. We don't have a scrolled 5-piece in one document, so I've got to go fishing for each one separately. So let's see, after number 1 would come number 2, I think. Is that the way that works? 1 and then 2? Is that pretty much normal? Is that normal? You never know. Okay, so here we have numero 2. Let me zoom in a little bit. See if there's anything. This is key here, the very top where it says the proper de novo standard of review. See that? Because we know that, at least according to the single justice discussion, she used a abuse of discretion, which is wrong. And the key difference is you're not just looking at what the judge did in the underlying case. You have a chance to look at new material, to view it anew, and it's a much broader review.
Right. And then there's a third page, and I think the most interesting part, I don't know if you're going to find that.
No, I'm just kind of reading through this because I didn't get a chance to read it in too much detail. So they're referencing, of course, the scram, which was the issue and the reason they went in for a modification. But it does hit, again, some of the high points that were referenced in the original papers. Instead of a request for surrender from either the Commonwealth or probation, the court revoked the release plan and without notice put Ms. Fitzsimmons into custody for 180 days. The court then walked off the bench, ignoring counsel's argument for reasonable accommodation, alternative testing, urine testing, and the required least restrictive terms of release under 58A. So there are both legal and factual arguments being made here. And again, this alternative testing, we at Justice Serve TV are going to pay for that, whatever it ends up being, so that it's one less issue. Hey, will Justin come after us? Do you think he'll try and...
If he does, he does. Go at it. We'll be ready.
I was being facetious, but you may be right. Yeah, he. Can you imagine, as he's standing there, is he thinking, I caused all of this by, trying to take the baby, whether he thought it was the right thing to do or the wrong, and she gets shot, almost killed in the process. Does he have any responsibility in his brain for that?
Maybe we'll find out someday.
Here's page 3. Yeah, we may never find out, but whoops! But it's rattling around in my brain.
Yeah.
Okay,
down at the bottom, I think the most important thing is
in-person hearing request. Is that what you're looking for?
Yes, that's what I'm looking for.
Okay.
That means that the petitioner respectfully requests that this court grant an in-person hearing and hear oral argument on the matter, because it involves a large body of evidence and asks in favor of Ms. Fitzsimmons' release that has gone unaddressed in the prior reviewing courts. The petitioner asserts is determinative in favor of release and should be considered and noted. I mean, we don't even remember if anyone, if the single justice who again recused herself and is not supposed to talk to the other justices, all right, even listen to the tape. But certainly in a hearing, Mr. Bradel can address this. So then there is an expedited hearing request also. So this is a very short, simply direct to the point written petition. Is excellent. And by the way, you're only allowed 10 pages at most anyhow. So you better be short, sweet, and excellent and to the point. Okay?
It is truly a brief. So then key is what they're looking for, and that's laid out here very clearly. Address the bail determination de novo, consistent with the applicable case law. Grant Ms. Fitzsimmons an appropriate release decision for a police officer charged with 1 indictment, a 5-year felony for which she qualifies under the guidelines for probation, personal recognizance, and a stay-away order under Section 57, no finding of dangerousness required, or additional conditions under Section 87, bail terms imposed with agreement of the defendant, Chapter 276, or grant other such non-incarcerative relief if the alternative, the court deems that necessary. So, and there's a little bit more, which I will get to in just a moment. But
as you get into that, please remember to hit that subscribe, like, share, notify button. I have to say that at least once during this broadcast, although you'll probably hear it more and more as we continue to go through this, because it's important.
Just a couple more pages.
This is what we've all been waiting for.
I thought they were waiting for your picture.
Fashion Friday.
Yeah. And send the case back to the Essex Superior Court before a different judge. Oh, Domino's just waking up.
That's Domino's. Tubi's like, I want to go out.
Am I ignoring you? Am I? Yeah. All right. He's at shift positions.
And by the way, as you're hitting that subscribe and looking at this, we're also going to have Monday night a very special guest on. But you guys have to stay tuned and follow us, and so you have to subscribe to us to know who that guest will be.
Yeah, it's going to be something.
We won't be announcing it until Monday.
Yep, it's going to be something. Let's put it that way. Let's see. Yeah. Oh, for the reasons set forth in the petitioner's single justice brief. Got to get a new judge, and so he doesn't regurgitate a lot of that here. But if you read the first petition, he blasts Judge McCarthy, which I think is appropriate.
Yeah, right. We all, those of us who think it's appropriate. And while we're not supposed to badmouth judges as lawyers, as journalists, boy, we can. Okay.
And I like the footnotes is where all the good stuff is. If you look at the bottom here, footnote 7, Ms. Fitzsimmons respectfully submits that it is imperative for this court to listen to the recording of the trial court bail hearing. And he and I talked about this. How I know you supplied it, but the decision by Dewar made it seem clear to me she didn't listen to it, because she would have said something other than the transcript of. Right. So he's asking for it here in pretty basic terms. Exhibit 1 of the single justice petition. The single justice apparently only reviewed the transcripts later provided by the Commonwealth and was not able to appreciate the egregious treatment of the defense and the probation department, which is made clear by listening to the hearing culminating in the judge departing the bench while defense counsel was mid-argument. No reasonable listener, I think that's how we've phrased it many times. No reasonable listener can reach the conclusion that the court approached the matter impartially. Yeah, we still don't know the motive for that lack of impartiality. Something's going on. There's something. You don't just act like that without some sort. I can't believe she's that just generally evil. We've heard from some folks, attorneys that names you might recognize, that that Judge McCarthy is fine. She's a fine a judge. But at this point, all we have to judge the judge on is this one event, and she hasn't come off smelling too good.
Yeah. And by the way, this brief also addressed other issues such as not only the errors of law and discretion, but the fact that there were actual constitutional violations with this decision, making the ability to go federally with this should there be an improper decision after an exhaustion of these remedies, administrative remedies. So, or even not, if it's constitutional, you don't have to exhaust your administrative remedies generally. But although with this court and the Supreme Court, I think that maybe doing things safely is probably the best way. You can't go wrong if you do address them, if you then get to take an appeal.
Yep. You got to be thinking 3 or 4 steps ahead. The court is empowered to apply its collective trial court experience. And I remember Judge Tim Bradel saying that Judge McCarthy really was, Justice DeWar did not have a lot of trial court experience. And he felt that kind of made it difficult for her to come to the right conclusion. This court is empowered to apply its collective trial court experience and knowledge to, quote, consider the legal rights at issue and independently determine and apply the law without deference to the respective legal rulings, end quote, and harumph. There's no reasonable scenario in which Ms. Fitzsimmons should be held or be subject to the panoply of harsh conditions imposed by the trial court. No justice on the instant panel would impose such conditions and then incarcerate petitioner as a result of a serious health issue, making compliance torturous and painful. And remember that word torture, came back to haunt because Judge McCarthy decided, well, we don't want to torture. We're not going to do that. So the best way to have her comply with the release conditions is make her no longer released, which is the weirdest twisted thinking I've ever heard. Let's see, is there anything else on here? Blah, 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 and scene. So I think we've covered all the guts of that there.
Yeah, my microphone fell off. So.
Nobody likes your microphone. So this is like a one you could use, for your kids or for your, yourself. Power on. Ooh. Just a moment, please. Of course. Thank you for being polite. And then it gives you a time you breathe into it, like something like this. Please blow. I had to double breath that. That's not good. Ooh. Oh, but it says I'm normal, but my wife might disagree. Says I'm normal.
Wow, but you see, that was hard. That's if you go to to a lung doctor and you have to breathe in those machines. Anyone's had to breathe in those machines.
That's like one of these things, yeah.
Right. They don't want you to take that breath. Even when you get operated on, like when I had my hips replaced, I had to keep breathing to practice today because they want your lungs working and they want you to breathe. It's very, very hard. And that's when you don't have damage to the ribs around your lungs, around your rib cage.
Yep. Oh. So would it be so difficult to make accommodations? No, it would not. And we're here to help make that happen. So hopefully it will. All right. Weekend plans? Anything?
Weekend plans. Let's see. The Jets are playing. No. Okay. I'll just be working this weekend for the most part.
Okay. All right. So I'm looking forward to Monday's interesting surprise.
And looking forward watching Donna Edelson this weekend. Though I am doing that on Saturday.
Yeah, I forgot to mention that. We finally got, after begging for 10 days, all of the final body cam and transport video. It's fascinating, some of the transport stuff. But what happened was, this was our own fault. We started running some of that stuff before and after the verdict, right? And other people went, oh, that's kind of cool. Tons of folks started asking for the same stuff we've had all along. And so it backed them up. And they have 2 people in their department. One person was sick. So the other person had to do everything. And anyway, so it was a little slower in coming. Remember, I used to say how great they were doing in Leon County. You'd request the stuff and boom. Difference this time, when I called and finally got them, they didn't charge this time. Every time they've had video that they provided us, they charged, $20, $40 for the manpower to do it. I think I guilted them into giving it to us for free. So that's I'm going to get to it as soon as we're done. Post all the raw. Then we'll talk about it over the weekend. We do a little an episode. It's kind of a big snack. We decided it's kind of like a midday meal. It's not quite snack. It's a little longer, where we analyze what we see, but we want the raw video to be up there for you sooner rather than later.
So he's going to put the raw video up, and then you'll hear we have pre-recorded a show where we analyze it for you tomorrow. So wait for that. And then of course on Sunday there is tea time with Jack the Ripper. Everyone loves my nails. Not my microphone so much, but loves my nails. Yeah, this new nail color.
Those are a Fitzsimmons purple. Okay.
Yes, they are. How'd you know that?
All right, then. Michel Bryant here. Thank you, Linda Kenney Baden. Have a great weekend. Everybody, have a great weekend. We are Justice Served TV. Please try to do the right thing.